So what's going on with you two? We went ahead and hit the live broadcast, so we've got about 20 or so folks already looking in over our shoulder. Hi guys, we're going to officially start this thing at 10 o'clock. I've got John and Craig with me right now, and John, you're a traveler. You're a world traveler. Where are you going to be coming up soon?
Let's see. My next trip will actually be for business. I was invited to go teach the appraisers at the Santa Ana Hawk.
Oh, nice.
So I will teach them 14 hours of CE.
Is this the FHA appraisers, I guess?
Yes. Huh. They are appraisers. They need continuing education as well.
I'll be there. Well, that's interesting. Is that open to anybody that might want to set in, or is that a private?
It's private. It's through their facilities. I don't know that they would just allow anybody in. They've got it's all got to be paid for. So
yeah. Craig, what you been up to? Where you been lately?
Well, we've got a little bit of a whirlwind going on right now. I just got back up from the first of the ICAP summer seminars here in Illinois. I was down in Collinsville earlier this week. Great turnout from folks down in the Metro East and St. Louis area, so that was great. And we're just keying up for the summer here. So we've got another one of the summer seminars coming up in Springfield next month. And then we've got the big one up here in the Chicagoland market out in Lisle in August. Working on a couple articles right now too, and every once in a while in between that, I still practice law. So
you actually do something you could bill for. That's great. How many folks do you know roughly? How many folks are a member of that coalition?
Ooh, that's a great question. I don't. Last I heard, it was somewhere north of 1,000, but I don't remember exactly what that is, and that might be a little bit dated info right now. I know they're big. I believe they are still the largest of the coalitions out there. I don't know what the exact numbers are right now.
That's fantastic. That's a good group, and as I travel around, I'm surprised there's a lot of states that don't have any type of representation, any type of organization, and we certainly encourage folks to do that. As in Arkansas last week, and they said, we've got one. No, we don't have one. Yeah, we have one. They weren't really sure where they were. And I know some states do have organizations. I know Tennessee's come a long way. Initially, they had some growing pains, which is understandable for a new organization. Kentucky as well has been there and then dwindled and then come back. So it's kind of interesting.
Hey, Brian, on the NAA Appraisers website, so National Association of Appraisers website, naaappraisers.org, there is /state organizations. There's also some links you can get to it through the directory. There is a map of the U.S., and the states are shaded, and or if they have multiple organizations, those are listed as well. So an appraiser can find their state organization right there, and if there isn't one, then it's just white. So Arkansas does not have a coalition. I will tell you this: Oregon at the Arrow meeting, 4 of the Oregon appraisers that were involved in forming that coalition. The NAA helped assist, at least with providing some framework documents, bylaws, things like that they could adopt and tweak for their own purposes. They formed the Coalition of Oregon Real Estate Appraisers. And so they are actually going to join the Board of Governors, but they are the newest state organization. They're still not shaded on our map yet. They are in the process of obtaining a domain, but I believe they've already registered with the Secretary of State and all that good stuff.
That's fantastic. Listen, appraisers need to get involved, and if they need help with that, John's the man that can kind of help you, or at least point you in a direction of help. I know when Gene McCarty kind of got the Mississippi group together and going, and it's snowballed. They've got a great group down there now. But early on, I was teaching down in, I believe it was Pearl, Mississippi, around Jackson. and we were talking, and they were just kind of kicking things off. So it's great to see how they've evolved. Hey guys, it's 10 o'clock, so we're going to go ahead and get started. Good morning, appraisers. I'm glad you're chiming in, and any other users or other just curious folks. We have appraisers and real estate agent, attorneys, title companies, a wide variety of audience participants, and we're glad to have you here. I have two guests today, and I'll tell you who they are, and then I'll let them speak about themselves slightly. Mr. John Dingeman is the president of the NAA and a chief appraiser with Landmark. And Mr. Craig Capilla is a practicing attorney out of Illinois. And if you don't mind, guys, go ahead and just kind of elaborate a little bit more on your credentials. And if you don't mind, let our viewers know how they might be able to get in touch with you should they desire to do that. We'll start with the attorney because I don't want to get in trouble today. Craig, go ahead.
Wow, that's nice. Get to bat lead off here. All right. Well, first of all, thanks very much for having me back on. I always enjoy being able to join you here. Now I'm going to immediately dive into the lawyer thing and let everyone who's watching at home right now make sure they're abundantly clear that this is not a legal opinion and it does not constitute legal advice. If you do ever have any questions or concerns, please do feel free to reach out. If we can help you, we will. If we can direct you to the right resource in your area, we are also more than happy to do that. I'm an attorney here at the Franklin Law Group just outside of Chicago. And I'm actually licensed to practice in Wisconsin and Illinois, do a lot of appraiser defense work at license boards as well as in civil suits. That's actually the question I always get right now. How many do you have? The good news is I have only 2 lawsuits going right now. Those numbers are way down. Board complaints are still happening, but those have fallen off a good bit as well. So that's kind of my good news. I will put up on the chat here so it can be sent out. I'll throw our website up there as well so people can take a look at that if they do want to reach out. But it's charlesfranklinlaw.com. So that's the background on this. Came from a board prosecutor perspective, came back out into private practice, and now we're out here defending licensees and defending professionals in civil suits.
Great. Thank you very much, Craig. John, take it away.
Well, let's see. I am, as Brian mentioned, the president of the National Association of Appraisers. Currently, I am in my 2nd term. I love the organization. I think we're making some great headway in helping appraisers. This is the discussion today is just one of those instances. As a representative for the NAA, I do my fair share of travel, as you mentioned earlier. So I have actually this week returned from the Appraisal Foundation Board of Trustee meetings. The 2 weeks prior to that, the ARA meetings, which is the Association of Appraisal Regulatory Officials. Before that, you and I saw each other. We missed Craig. He got caught up in a case at the Appraisal Conference and Trade Show, which was the NAA's first trade show, which occurred in Nashville, Tennessee, which, by the way, was absolutely awesome. And next year, the UAU, the Utah Appraisers Association, did I get that right? They basically won the bid, so we will be presenting acts in the Salt Lake City area next spring. Dates to be determined.
Very good. And we had a fantastic time here in Nashville, Tennessee. The NAA as well as Appraiser eLearning came together and put that event together. It was fantastic. I'm still hearing comments from my students and folks I bump into on a regular basis, what good time they had. They learned a lot of information, and boy, they really liked the fact that we not only gave them breakfast, we gave them lunch, and on the breaks, of course, you typically have coffee and Cokes and cookies, but man, that last break on the 2nd day, boy, for break, we had beer and wine and wings and salsa. And, people have written to me and said, you keep having events like that, we'll come to every conference you have. So again, I'd like to welcome all our viewers. I'd like to welcome my guest. I'm Bryan Reynolds. This is the Appraisal Report webinar hosted by Appraiser eLearning. We're excited to have you here. There's a lot of exciting things going on. And guys, I'm just going to call this our our win-win or really win-win-win segment for appraisers, because we really have had a lot of things occur that all appraisers should absolutely be excited about. This is good news. We live in a world of a lot of bad news, and we live in a world where we hear a lot of complaints and negativity all the time. And wow, we've got some good news for you. So I'm glad you're joining in. I'd like to also remind our viewers this is being recorded. And if you can't stay for all of it, or if you want to refer a friend to come take a look at it, it is recorded. Just check out our YouTube channel, hit subscribe, and you'll continue to be in the know. Also, I want to remind our viewers that we do accept your questions. So if you have any questions for myself or Craig or John, feel free to type that in and we'll get to as many questions as we possibly can. So let's just get right into the weeds here, guys, and talk about a few things. Many of our viewers know, but there might be some that don't know. There was a recent request from a bank, actually, coincidentally, here in Nashville, that was claiming that they had a hard time finding appraisers. The cost of appraisals skyrocketed. The turn times were extended. And so what they did, which you can do, there is a provision in FIREA. FIREA is the object, or the federal law, I suppose, that requires states to use licensed or certified appraisers for federally related transactions. But there's a provision in there that, to my knowledge, and Craig, you can help with this, there's never been a request until now. This bank actually made a formal request to waive appraisals for the entire year of 2018, at least appraisals by certified or licensed appraiser. Subsequently, there was another request that came in from an Oklahoma bank. I believe that was Citibank and Trust, John told me. And so we've been in this kind of stage of unknown. You know, if the appraisal subcommittee granted this request for the period of 2018, banks, or at least this bank and probably extended to others, would not have to get an appraisal by a certified or licensed appraiser for a refinance or for a purchase. And so if you're an appraiser out there, if you're a practitioner that relies on mortgage work, this would have greatly impacted your business model. They did come to the hearing and a decision was made. So before I let our attorney, or the attorney on the camera today, kind of tell us what happened, John, what did you and the NAA do? I mean, were you silent on this, or did you yell from a big stump? Talk about what NAA did.
You know, so Brian, the NAA board, we started to draft a letter almost immediately with regards to the first request that came from Tennessee. And before you know it, Bill Garber and the Appraisal Institute have reached out to, I don't know, probably 20, 25 different organizations, both national and state organizations. They had already drafted a letter. It was very well written. And he asked if we would be willing to sign it. We reached out to our board of governors and state organizations, some of which had already agreed individually to sign. We wanted to make sure that they were okay with it. And we decided, you know, again, partly based on my own personal experience involved in politics, et cetera, that it would make a larger statement to sign that letter together with the AI and the other appraisal organizations. And I think you're trying to show that there. We did begin to, or actually have a draft letter to the ASC regarding the Oklahoma request. That request was withdrawn. Interestingly enough, at the last two meetings, Jim Park made his presentations to Arrow and then to TAF. And in those instances, one of the things Jim talked about is when the request is made, a subsequent letter is sent back out asking for evidence to support the request or whatever. I believe the answer was Oklahoma must have thought that it was onerous and they didn't have enough information or didn't want to, so they simply withdrew their complaint. or their request, not a complaint. We ended up not sending that letter. There was no placeholder for it. We asked the ASC about it, and they said, look, you can send a letter in all you want, but it really has to address a specific issue. The other thing, and Craig, you can maybe speak to this a little bit. It was interesting for me. I know that we have some members that they want to respond now proactively to future requests that may be made, and we know that they will come. One of the things that I learned during these two presentations from Jim Park from the ASC was the requests have to be specific from the bank, and therefore the response or the letter has to be specific. And Jim believed that that letter that was written by AI and signed by so many state organizations, not only did it speak based on the volume of organizations that found consensus, but it was also a very well articulated letter to the point in addressing the facts of the request with data and stats, et cetera. Not so much of an emotional response, but the fact was we addressed it specifically instead of anecdotally or from 30,000 feet.
Yeah, and before I get Craig's input on this, I just want to say I want to thank the boots on the ground practicing appraisers that got involved, because there were many. Listen, if you don't think you can make a difference, you need to wake up, because you can make a difference. We had, I think it was like 75 appraisers sent in letters, something like that. Many practitioners here in Tennessee reached out to me personally. They said they were going to write a letter to Mr. Jim Parks. They showed me copies of the letter. A lot of exciting things happened. I saw that, someone would email me, and then it would be a chain of another email where they had forwarded it to 20 other appraisers. I had appraisers come up to me and say, well, if TriStar Bank has a shortage of appraisers, I'm going to call them up and ask to be put on their approved appraiser list so that you won't have a shortage anymore, TriStar. Here you go. And so it was really interesting to see the appraisal population jump in on this and come together. And I know the Tennessee Appraiser Coalition, Creighton, the president at the time, did a lot of work with that and got appraisers together as well to be vocal and to let folks know, hey, there's not a shortage, at least in this particular area. Hey, send me some work, I'll do it. So Craig, you had the letter up a moment ago, and since you're going to be speaking, it's coming to you. So you can either put that back up or do whatever you'd like. Tell us what the process is. There is if I understand it correctly, there is a provision that would allow, under certain circumstances, a bank or financial institution to be successful in getting a waiver. It's just, it was kind of proven in this particular case that there wasn't the dire need as such the request made it seem there was. So number one, tell us a little bit about the law, and can this happen again? And then number two, I'll go ahead and let the viewers know what happened at the appraisal subcommittee meeting regarding TriStar Bank's request.
Yeah, absolutely. So let's go ahead and jump right in at that point. And your question was, can this happen again? And my answer to you is yes, this will happen again. Okay, not can, will.
It's a matter of time, huh?
And that's an important feature here that I want to make sure everybody gets squared away. As you said, kind of from the outset, yeah, this is the first test of this provision. We've had this language in place since the savings and loan crisis and collapse, and this is the origin of the regulatory programs when state licensure first started to come into effect. This trigger has always been there. It's just until the fall of 2017, nobody had engaged this yet. So what we now have in front of us with this decision is this is the first guidance that we really get. And if you recall, when we spoke on this back, I think we spoke on this back in the fall sometime when the initial request came in. And in short order, within 30 days of the TriStar request, came in the city request as well from Oklahoma. So obviously there had been some conversation somewhere in the background on the lending end of testing the waters here. There is a lot of procedural work that needs to get done to sustain one of these. And, I had my opinions on it at the time. We had a pretty robust discussion about how we think this is going to play out, but we were also a bit in uncharted waters here. Well, we got our first chart. We have a map now of what's going on. Really quick, I want to echo some of what's already been said here in that the organizations getting together, everybody getting and pulling in the same direction was outstanding and was a very significant factor in all of this. I mean, think about all the state level organizations, think about the national organizations, the associations. NAA was absolutely getting out in front of this stuff. Obviously, AI National jumped on board pretty quick. IFA, ASA, you name it, all of the big players and all of these state coalitions, this is a bit remarkable here, all were able to put their heads together, agree on something, and go forward with it, which is a great sign. And yeah, that single letter signed by every organization under the sun carries huge weight. I don't want to diminish what the individual letters can do. There's a bit of a conversation John and I had prior to going live here today. There is a risk if individuals all send 10,000 copies of the exact same letter, it sort of just counts as one letter.
Right.
So there does need to be specificity. There does need to be something. There does need to be something unique, something novel in the thought to make it work. But don't see that as a discouragement from doing it. You're still better off doing something than nothing.
So Craig, let me
go ahead.
real quick. So what I'm hearing is don't let someone write a master letter and everybody sign it and send it in. As far as the individual appraisers, what would be more effective is if we all wrote our own letter, even if it was concise, right? You don't have to write a novel, folks. I'm a talker. I'm not a writer. Most people know that about me, but yeah, I can fire off a couple of paragraphs. That doesn't take that long. But I want folks to realize you're not discouraging them from writing a letter. Let's just write in 10,000 letters. If they were individual, has to get somebody's attention. Yes.
Yeah, by sheer volume and scope, it's still going to send the signal that people are paying attention. And look, in this particular circumstance as well, this was a great outpouring of concern and voicing a position on this. I'm going to throw up on the screen really quick here a copy of what's actually in the Federal Register. If you go to the federal government's website on all this stuff, you can see a copy of this is the official decision. And so you kind of see the header there. I'm going to go, because in the discussion of this, there's a great analysis, there's a great summary that's made. I'm going to highlight it on the screen right now. The appraisal subcommittee received 166 comment letters in response. Now, understand that's the totality of it.
Right.
Some of those letters were, in fact, in support of a waiver. Some of those letters were opposing the waiver. The association's letters absolutely counted in that. But just think about that for a second. 166. Okay, there's a lot of appraisers out there. 166 doesn't seem like that big of a number. Now, 4 or 5 years ago, I was at a seminar, and Dennis Badger was at the seminar as well. I've known Dennis for quite a while now. When I first got into the regulatory area, Dennis was one of the guys who actually taught me how to go through the investigative process and all that. He was discussing publications of drafts of USPAP and other rules and regs and how those exposure drafts get viewed. And when you think of, at the time, there were some 90,000 licenses floating around out there. I think we've kind of targeted in on somewhere 75,000 is the range now nationwide for appraisers. And they were getting 40 comments,
Right.
4 comments. I mean, it's shocking how little input they get on those sorts of things. So the fact that there was 166 comments on this issue already says to me that people were paying attention, and I think that's great. I think it's also important that we need to encourage people that we need more still. Get involved in your state level associations, get involved in your national organizations, speak up there and make sure you get your thoughts heard. This is not to discourage sending those individual letters, but also get involved in those processes, because that one letter with a signature block that I'm flipping over to that on the screen now, when you've got a signature block that looks like this with all of these different associations, that's what's going into the analysis here that we see. And so you asked the procedural question. Well, I think what happened here, this is really important. This is why we will see this issue again. The part that I'm highlighting right now on the screen is our roadmap, okay? In their analysis of this, we now know exactly what has to be done. And this is the law geek coming out. We like it when we get instructions about how this works. This is to prove something, there's elements or there's prongs. And this is a 2-prong question. First, the requestor of the waiver has to prove a scarcity. That's the word. Write it down, everyone. They have to prove a scarcity of appraisers in the relevant geographic area. Okay? That's the first test. You have to meet that point. But even that is not enough. You also have to show that the scarcity has caused significant delays. Yes, we are going to see another one of these, and it's going to come from a lender who is reading the same thing we're reading right now and figuring out how to articulate their request to address those 2 points.
Right. And let me ask this, Craig. So here's our 2 points, 1 and 2. Number 1, scarcity. So my question with that is, what defines scarcity? And then number 2, has caused significant delays. Well, what is significant? So, so there's room for argument there, or questioning in those. I mean, what basis are they using to make those determinations?
Well, and that's where all of this is going to turn. The requestor is going to have to articulate those points. They're going to have to supply data, supply evidence that speaks to scarcity and significant delay. Here in this particular instance, there was somewhat limited data about what that scarcity might be, and the best articulation of significant delay was that the wait time, the turn time, had increased an average of, I believe it was 6 or 7 days. That the board here was not persuaded by that kind of gives us insight. Okay, 6 days, 7 days is not significant in their mind. Furthermore, the data relating to scarcity was questioned. TriStar presented their numbers in the request to the panel. The organizations all got together, and this goes to John's point, the organizations all got together and responded specifically to the request by providing additional and, in certain cases, contradictory data that was at least persuasive to the board that maybe TriStar doesn't have all of their facts straight here. Additionally, there's commentary in the order and opinion itself that various individual appraisers also reached out with their own bits of data that seemed to indicate their actual real life circumstances, their experiences, were not counted in the data that TriStar had provided. So it began to poke holes in that kind of idea. That is a significant standpoint. All right, so we're going to go ahead and get this one off the screen for now.
So yay appraisers for doing that. You can make a difference. And it sounds like to me, the trier of fact, in this case, the appraisal subcommittee, would render that decision as to significant and scarcity. But now we've kind of got at least something to hang our hat on. Hey, I've got a question that came in and it's on this issue. And then after this, Craig, go ahead and tell us what happened. Okay. So Tim asked a question, given the fact that TriStar's logic was not persuasive, by what logic and reasoning will offer banks and lenders making the same request, yet they expect a different answer? I think you kind of covered that. They just need to do a better job with their request, right? With scarcity and significant delay. Would that be your answer to that?
Yeah, exactly. I think the next request that comes forth is likely going to come and address those 2 points. And look, I think the next response from the profession is going to key in on those points. I mean, John, now that you've got a chance to see this and I'm speaking to you with the NAA hat on right now as an organization. So certainly you and the directors and everybody, I mean, does that here respond, or does that kind of point you in a direction for how you are going to consider these waiver requests and how you're going to get back into the game when the next one comes in?
I mean, definitely, right? So, and especially, being present and listening to Jim's decision and how they made that decision, and what I had previously mentioned before, really trying to take a step back. I know it's hard to do, but take a step back from the emotional point of view. The argument is you're crazy. There's no shortage. Just you're trying to kill our profession. You're trying to make it so we don't exist anymore. We serve no purpose. All of those kinds of things. It's a very self-serving argument. One that politicians usually don't listen to. One that maybe courts don't even give too much credence to. But the fact that the individuals writing this letter and the focus was on the facts and the request in its totality, and then we offered those very specific answers, I think was critical to the success of that. I would also say, congratulations to the appraisers that responded as well. Again, both the Tennessee Appraisers Coalition, who provided some additional data, but how about also those appraisers that said, wait a minute, TriStar has never asked me to serve on their panel of appraisers. Here's my license and information. I'm willing to help them out so that they are not feeling this pain point. But I think it's very important that we read the letter or request that comes in the future. We articulate a thoughtful response specific to the letter or the request, rather than necessarily our own opinions and from that point of view, right?
Hey, I have another comment that just came in. I'm going to read this. It doesn't appear to really be a question, but it's a comment from Scott B. Scott says TriStar's request was Bush League. Had they hired counsel to put together a well-reasoned, legal, and evidence-based argument, the outcome might have been different. And I believe that's what you're kind of speaking on, Craig. John?
Craig maybe has a different response. I mean, for me, listening to the decision from the ASC, there was enough evidence to support that from the appraiser's point of view that there was not a scarcity, not particularly in the 4 counties surrounding Nashville that the request was made for. So I'm not sure that it would have been successful if they had better argument.
Yeah, I think one of the counties was Davidson, wasn't it?
Yes, it was.
That's Nashville, for crying out loud. It wasn't out in the middle of God's country, where you have one appraiser servicing the area. It's Nashville, for crying out loud. And yeah, I know numerous appraisers that said, we've reached out and said, hey, you got a shortage? I'm willing to take more work. Send me some work. I'll solve your shortage issue. So I don't know.
So Brian, hey, look, maybe to answer Scott's question, it would have to be twofold, right? One is they would have had to have a better argument and better counsel to put together that response. The second would have been a disjointed appraisal community that really, again, as I pointed out, is going to argue based on their feelings that rather than the presenting evidence to support the opposite effect. So
Right.
I think those two things, if they were completely opposite, then the outcome would have been different. But thankfully, it was not.
Yeah, absolutely. So speaking about the outcome, I don't care, Craig or John, either one of you. What's the outcome? What happened?
All right, well, I'll dive back in on that one. I'm gonna actually wrap up that last point first because I think John was driving in a really good direction there, and I'm gonna kind of key in on that, and I think I'm gonna support exactly what John was saying. Well, first from the lawyer perspective as to whether or not the outcome would have been different, I'm gonna give you the lawyer's answer, which is, well, it depends.
I knew that was coming.
But understanding that, I think the facts in this particular circumstance likely would have resulted in the same outcome no matter how it was articulated. There's an old lawyer joke. If you've got the facts but not the law, pound the facts. If you've got the law but not the facts, pound the law. If you've got neither, pound the table. Okay? This was one where I think the facts favored the appraisers, and it didn't really matter how the law was written. The facts were going to bubble up to the surface here and result in the outcome that favored the appraisal profession. But now we have a roadmap. We know what the appraisal subcommittee is looking at here. We know what is going to be weighed and considered when this next request comes in. And I want to encourage, this is the bigger operations now. I want to encourage the state coalitions. I want to encourage the national organizations. Start detailing your responses now, because you're going to have to move quickly when the next one comes in. Again, we all know what's being weighed out and considered here. So get that data. This is the stuff you can start figuring out. Look in areas where you might think there is some sort of a potential scarcity. Again, that's the key word here. So let's start keying in on what states might there be a scarcity? What counties within those states? We should be able to drill down on that information at this point. Look, if you've got a circumstance where you are in a particularly rural area and you've got one appraiser for multiple counties, guess what? That just might show scarcity. Or, hey, maybe we're just going to go ahead and do evals now because we have those rural areas that might be considered commercial parcels, and they might just happen to fall under that $500,000 threshold. Or we've got SB 2055, that's just a ticking clock right now, where we're talking about rural exceptions already. Folks, these are all happening in concert with each other. So be prepared for what those responses are going to be. In this instance, the TriStar waiver request was denied. TriStar has been informed, no, you don't get the waiver you're asking for because you haven't shown us that scarcity, and you haven't shown us that the scarcity caused significant delays. But that's in this circumstance. And this is an interesting twist that I want to make sure everybody has straight on this too. The ask here was based on the availability of commercial appraisals, okay? Commercial appraisers, rather. But understand that the way this provision was originally drafted in Title 11 to make this request, there's not a lot of latitude for what the ASC can do here. This is effectively an on-off switch. Some of the requests and some of the comments throughout this process were about, well, let's just get rid of the requirement to have an appraisal. No, they don't get to do that. They only get to consider whether or not a certified appraiser must be utilized. Some non-certified individual, if in the event that a waiver is granted, a non-certified individual can go out and perform an appraisal, but the appraisal must still get done. It just need not be done by a certified appraiser. The reason I bring up the idea that this was based on a commercial scarcity or a dearth of commercial appraisers is that same idea that this is an on-off switch. The argument here is that the turn time on these commercial assignments is a problem. We don't have enough commercial appraisers to do the work, so please grant us a 1-year waiver from this requirement. But it's not a waiver of the requirement on commercial assignments. If the waiver is granted, the waiver is granted to that lender for all lending assignments, which means that they no longer need to use a certified appraiser to do residential work, which is presumably a lot more volume. But you frame the argument in, I can't get a commercial appraiser, and now I've bought myself 12 months of, I don't need an appraiser for anything.
Right.
That's the problem here.
Yeah. So the question is, were they only going to use that waiver for commercial, or since it opened the door for everything, of course they're going to use it for residential. They're not going to get an appraisal on anything if that thing had been granted. That's obvious. And Craig, my understanding is that if they had been successful with this, wouldn't this also extend to any financial institutions servicing those 4 counties? Am I understanding that right? Or would they have to make a separate request for that?
So procedurally, I got to tell you, I'm not entirely certain about that, because I've actually seen discussion that goes both ways.
Okay.
I've seen that then the other lenders might have to assert their own independent request, but hey guys, if it's good for one, it's probably going to go through for all the other ones who articulate the same point. The numbers, the data doesn't change at that point. Yeah. I've also heard that, nope, it's just automatically going to apply to all these other lenders, because of course it would, because their argument would be the same. So procedurally, I don't know how the ASC would address that.
Okay.
Fortunately, we didn't have to find that out here.
Yeah. Regardless, even if it didn't open it up immediately, it would be a snowball effect. There's no question whatsoever. Other banks would follow suit, and that was evident by Oklahoma, that Oklahoma bank, by doing so, and then they withdrew their request for whatever reason. So, hey guys, we're at the halfway mark. I would like to again remind our viewers that these sessions are always recorded right after the broadcast. They're pretty much available via recording. If you have any questions of our guest or myself, feel free to type those in. We'll get to as many questions as we possibly can. And the Appraisal Report webinar is hosted by Appraiser eLearning. We're happy that you're here. We'll continue these free webinars. And if you have an idea for a future webinar, please email myself or one of our team members. Let us know. Or if you would like to be a guest on the Appraisal Report webinar, let me know, and we'll get you in that seat as well. So by all means, reach out to Ben or Doug or Hal, Jim, myself. Okay, let's move on to the next topic here. This is kind of exciting. You know, I still say when the new form came out, the new form's really not that new. In fact, we'll talk about the ramblings of a new form in a minute. But, you know, the form that we use presently for most mortgage finance transactions throughout the United States is the URAR. Some people call it a 1004 form. That's actually Fannie Mae's form number, isn't it? 1004. But we use that, we as practitioners use that about every day. And when that came out in 2005, there were some really big concerns. You know, on the first page, they took the word apparent out, where it says there were no apparent adverse conditions. Now, they took the word apparent out. It doesn't exist. I like the word apparent. I'd like to have it back. And then they added some certification statements, and one that we've always been extremely concerned about was certification number 23. Because we have traditionally said, you know, the borrower is not really relying on the appraisal when they enter into that contractual agreement. They typically enter into the contractual agreement, and then, as a consequence of getting mortgage financing, the bank will order an appraisal from an appraiser. So what reliance did the potential buyer place on the appraisal report in making their decision to buy? They had already made the decision to buy it. This is for the bank. But the certification number 23 was of concern because it virtually says that the borrower, another lender at the request of the borrower, and a whole host of other folks may rely on your appraisal report. So I was always concerned that may rely and intended use were pretty close. In fact, Arrow published a letter, I think it was in 2005, on this very issue. And it said that member jurisdictions of Arrow need to be reminded that they regulate appraisers, and appraisers need to supplement an appraisal report if it doesn't clearly identify who the intended users are. So, and that was all surrounded by certification number 23. So, Craig, tell us about this case, Tindell versus Murphy. What is it? And then we'll bring John in, because I know after one of the rulings, NAA sent a letter out, and I'm going to let John tell that. But thank goodness for NAA and that request, because it may just very well significantly impact appraisers from a positive perspective all across the United States. So, Counselor, tell us about this case. What was the nature of the case?
Okay, so this is a case now that comes out of California, specifically the Court of Appeal of the state of California and the Third Appellate District. So that is, in fact, kind of that's effectively, at least from where I'm sitting, that's right in John's backyard. So there's going to be some good insight that comes out of that aspect. There's a couple of things specifically that I want to say about this case, because there's a couple of different things at play here. First and foremost, the decision itself is very significant, and it's an extremely positive development from the court in their analysis. Then there's the second point, and I'm going to start first, and I'll roll back to the first point. The second point is the fact that this decision is published, and for lawyers, that means something that I think the average reader may not necessarily get. You're looking at the court published a ruling. Yeah, okay, well, that's kind of what they do, right? They make a ruling and then they publish it.
Hey,
and
Craig,
the answer there,
Craig, let me back you up if I may. There's some viewers out there that might not even know what this case is about. So what is the nature of the lawsuit to begin with? So set us up with that first.
All right, so let's set the table with that. So this case in particular deals with the liability that an appraiser may or may not have to the borrower in a lending transaction. And going to your point earlier about Cert 23, this is where that language now comes into play and how it comes back and interacts with intended use and intended user. There are some states that have gotten bored with this. California is, in fact, one of those states. There's an old saying that goes, as California goes, so goes the nation. Hopefully that means that other states are getting on board with this as well. Several already have. For example, I know Ohio is one of those states. But the idea is, does the borrower in the purchase, or rather the borrower in a transaction, do they really have the ability to rely on the appraisal report? And there's some nuance here, because I think there's question about what does rely actually mean. In this instance, there's a little bit of what would probably be considered a buyer's remorse, in that, well, gee golly gosh, that appraiser made me think it was okay that I should go ahead and buy this house at that price. But as we all know from intended use and intended user, that is not the purpose of this appraisal assignment. The borrower is more than welcome to go out and hire their own appraiser at any point, preferably even before they put an offer in on the property,
right,
to decide whether or not this is a good idea for them. But when the lender hires an appraiser, the appraiser is the eyes and ears of that lender for purposes of securing the mortgage in the transaction. And this particular California case further established that point, specifically that the request, this appraisal, was made to the lender, not to the borrower, and that it was reasonable that the borrower has his or her own means of ascertaining desirability. That's a line straight out of an earlier decision, but that was heavily leaned on here in this particular instance. Something that John and I actually discussed a little while ago. There is a predecessor case to the Tindell matter. And that case is the plaintiff in that case is Williamson. It's I think it's Williamson v. Metropolis or something like that. And I'm just going to butcher that name right now, so I apologize. But hey, that's in California. I'm here, so that's fine. That case really set the stage for Tindell. The court in Tindell was heavily reliant on that prior outcome from Metropolis, from the Williamson case, which was a 2014 decision that essentially laid out the exact same framework. What the determination of that court here was that supported the appraiser again was that the appraiser may have understood that the borrower was going to get a copy of this, but there's nothing anywhere in the record, there's nothing in the evidence that indicates the appraiser knew the borrower would be relying on the appraisal to inform their decision as to whether or not to buy the property. The appraiser knew that the lender would be relying on the appraisal in its consideration as to whether or not to fund the loan. But those are two very different things. That actually prompts kind of a different intended use here. The Tindell court then identified and leaned heavily on that sort of analysis to come up with the idea that, again, this report, this assignment is made at the request of and to the lender and for their decision-making process in the loan. So that's kind of the background of the case and ultimately where the decision was. And then there's the matter of publication as well. And so there's a couple things I'm going to put up on screen. The first thing I'm going to put up here is.
So let me make sure I understand this. So there was a lawsuit. So an appraiser did an appraisal, sent specifically for a lender, sent that in to their client. Everything's good. At what point in time, some point in time later, the buyer gets frustrated. Hey, I'm in a situation I shouldn't be in, and I'm going to sue the appraiser, right? So they sue the appraiser. It goes to court, and the court actually ruled on the side of the appraiser. So the appraiser won that case. Then what happened?
So then this matter gets sent up the appellate chain. The appellate court upholds the idea that the appraiser is in the appropriate position here.
So the appraiser wins again.
Yep. So the appraiser wins again, but we're now silent on this one.
Right,
this is the world shall never hear of this.
Right. So yay, appraiser. He won not only once, but defended himself or the attorney did, what have you. Won a second time. This is awesome, but nobody's ever going to know about it.
Nobody's ever going to know about this part until the various organizations start getting involved. And this is a critical component. This is why publication matters. Not all appellate decisions are published. And let me tell you, from a practicing attorney's perspective, how absolutely infuriating that is. Because sometimes there's a really good case out there that you know about and you just don't get to use it. So I put up on my screen a write-up here on this matter from Peter Christensen. Okay. Peter's out there in Santa Barbara. Peter's been working on this stuff. I know he directed information to the NAA, to the Northern California chapter of the Appraisal Institute, and those folks got involved in publication. So shameless plug for somebody else here. Appraisers out there, if you are not reading Peter's blog, if you're not going to Peter's website to see this stuff, you are doing yourself a tremendous disservice. If you see this valuationlawgroup.com, that's Peter's law firm's website. All of this documentation is contained on there, and you absolutely need to go read this. There's a lot of really good information on it, just generally, but this one in particular, Peter gives you a whole write-up of what the process was and how this went to get published. So you got to go see that. Also, and I'm switching over here. Here is the letter from the National Association of Appraisers requesting that this opinion get published, and why. And I'm just going to do this highlight because he doesn't get the chance to. See that guy up there in the corner I just highlighted? He's going to talk to you in a couple seconds here about what the process was and how they managed to do this. But I cannot stress enough how important these actions are to get these matters published, because here's a whole letter that gets sent to the court explaining why, hey, look, in case anybody wants to sign something with John's name, there it is. This is, I can't stress how important it is for these associations that carry heft, that carry weight, to get out and help guide the court in their decision on publication. Credit where credit's due.
So
they did that the first time too in Williamson, or you might never have read about that either.
Yeah. So, and we'll come back in just a second, Craig, and reiterate how you can use this information in the future. But before we do that, John, tell us, I mean, what was the process of NAA knocking at the door and saying, look, this is huge. This is big news. This can help appraisers out there if they are sued and really shouldn't be in trouble. This might be a precedent that they could call upon. We'll talk to Craig about that in a minute. But what was the process of the NAA making that request? How difficult was it? Just give us some insight on that.
Well, Brian, I mean, look, the board prior in 2014, when that decision with Williamson and versus Metropolis was decided in September of 2014, about a month later, the board articulated and wrote a letter. Mike Brunson, the president at that time, had made the request for publication, and our sole request was, look, this was an appraiser who won, as you said, right? They won, and we've seen instances where that has not been the case. We've seen instances where reliance, the borrowers had claimed that there was reliance, and the favors were not on the side of the appraiser. And so we were looking for an opportunity for this case, which we became aware of. It was not published. It couldn't be used by attorneys like Craig as precedents because of it. And so we went about writing the letter requesting publication. The letter is, you write the letter to the courts. I think the attorneys that are involved are also made aware of the request. They can certainly make a request to not publish it. The courts decide on that, and Craig can talk about that procedurally. But, look, the point, our point there was to take a case, Williamson versus Metropolis, allow it to be used as precedents, and 4 years later, it's used as precedents. That's important, and that means we won on that issue. But it's important again because not only that case now wasn't published, but it's important to stay on top of these things. If appraisers, our members, want to make us aware of certain cases, that we can also maybe in similar circumstances, and we can do the same thing. But it's just it's a letter writing campaign, Brian. It's just being on top of it. I know I get paid big bucks to work as president of the NAA. That's how much I make. But it's just going about it, being diligent, keeping your ears, open and listening for opportunities like this, and making the request. Once again, it can be used as precedents now that it's published.
Thank you, John. And hey, thank you for doing that. And I want to thank you on behalf of all appraisers, because guys, even if you're not a member of NAA or your local state association, I mean, first of all, you should be, but they do this not just for California appraisers, but for all appraisers. And so let's end on that, Craig. So NAA was successful in making a request for publication. It is a matter of public record now what the outcome of those, actually virtually, I guess, two cases, a case and an appeal, if you will. And now you can use that information. So could that help an appraiser in Kentucky or Tennessee or in your state of Illinois? What's the importance of that being published?
Okay, and so that's a really good distinction that I want to make here. So starting with Williamson and that decision and getting that decision published, that decision there is now the law of the land in the state of California. Tindell becomes important because Tindell is a test of Williamson, and the court determines, yeah, Williamson holds up. Williamson is really good. We agree. That was a very well thought out analysis and decision. And so we are going to go ahead and support that. It's been weighed, it's been tested, and it has survived that test. So Williamson is the law of the land in California as supported by Tindell. And that support being published is important as well because both of those cases are now precedent citing in California. Here in Illinois, it doesn't carry the same weight as precedent, but it does carry weight in the sense that it can be very persuasive. Believe me, if this issue gets to my desk on a matter here in Illinois or in Wisconsin, and I have to go ahead and articulate a legal position, there is every possibility that I am going to cite to these matters, especially if it's a state issue that has not yet been considered at the appellate or the state Supreme Court level. That means it's a case of first impression. It's a blank slate.
Right.
All of this stuff comes in and can be cited not as precedent, not that the court in the other state or other jurisdiction has to follow this. California courts have to follow this. Other courts do not have to follow this, but they may. And in a vacuum, this might be the best analysis, the best articulation they get. And so this is bigger than just California because it has the chance to pour over into all of the other areas. You know, when I said the joke was, as California goes, so goes the country. There's a truth underneath that statement, which tends to be that oftentimes California is actually out in front of some of these issues before other jurisdictions get it. And that's why that trend line exists, because it can be persuasive in a vacuum when no one else has considered it yet. So full kudos to the NAA for jumping all over both of these cases and pushing it to get the publication out there because it can support appraisers coast to coast. Full kudos to Peter for the work that he's doing, helping draft, articulate these explanations and persuading the court why these should be published. Full credit to the Northern California chapter here for also jumping on board and doing great work for their membership. And I guess I'll wrap up my point with that membership idea. I sound like a broken record at this point because every time we get together and talk, I get at this point. But look, I get to say this. I'm the lawyer. I'm not an appraiser. So I maintain membership in some of these organizations, the NAA, the ICAP here. We do a bunch of stuff with IFA. We do a bunch of stuff with the Institute. All outstanding organizations. Appraisers who are listening to this, you got to belong. You pick one, you find the right fit, get involved, and be active. Go to your state board meetings. Go to your association board meetings. You've got to get out there and do this so that these organizations know what your concerns are. They can only help you if they're hearing from you and they know it. John knows what affects him in his day-to-day basis, and he knows what other appraisers put before him. But if he's not hearing it, it might slip by. And that's not John's fault. That's the fault of the other people who didn't bring it to his attention, so he can't do anything about it. Get in and get involved. And I'll get off my soapbox on that.
Thanks, Craig. And hey, don't just limit yourself to one. You can pick more than one, pick two or three. We're okay with that. We're totally okay with that. appraisers get involved. I think that's what he's trying to say. And we're all very busy people, not just appraisers, human beings in general. We are very fast paced, instant gratification. There's an app for everything. We go, 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 go. So I understand. I don't have time for that. Well, listen, if this appraisal waiver request came through, you may have a lot of time because you might not have been doing appraisals for the entire year of 2018 in those 4 counties if they were successful. So you better get involved when there's a hot topic like this. John, what's your final thoughts?
Hey, I'm going to run just a minute over to, I want to give a word of caution as well. And I'm going to use it from my experience now as the chief appraiser at Landmark Network and just the volume of appraisals that I see, and in particularly with my own history related to intended users. My history was, I had a claim against me from somebody that was not an intended user. They were never named as an intended user, but they wanted to act like they were. And they use the word reliance. We can't modify or restrict, if you will, to a certain extent, the pre-printed forms and the certifications that are on there. But we can add clarification to those certifications, and I think that there's some opportunities to do so. Diana Jacob, in her books, Write It Better, for example, she gives some language for appraisers to clarify intended user. But my word of caution is this: there are so many appraisal reports, and I pick the phone up and I'll call an appraiser and I'll make the recommendation to them that they remove some of the intended users that they have on their own volition named. They start naming the appraisal management company. They start naming an investor that they don't even know is going to have this appraisal report. They start naming the Bowers by name, etc., as intended users. And my advice and word of caution is, don't add intended users unless that was part of your engagement letter that they be named. You're only increasing your exposure to risk. I'm not an attorney. That's just my opinion. Maybe Craig has something different to say on those regards, but I see it on an almost daily basis where the appraiser is, again, writing and adding intended users to the report. So I wouldn't do that. From my point, in closing, I appreciate both of you talking about joining and participating and finding your own niche, whether that's just being a member and paying dues so that the organization can do the things that you'd like them to do, whether that's participating on a committee, whether that's a state organization or a national organization. We all have talents that we can bring to the table. You know what your talents are. Your voice will be heard. And again, if you're not saying anything, then I guess it wouldn't be. But if you have a voice, it will be heard. And so we would encourage you to join. Go to naappraisers.org/state organizations. There is a map there. Look for your state. If your state has a state organization, click on that state and join it. If there is no state organization, reach out to the NAA, reach out to the leadership that you know in your state, and form a state organization or coalition. And finally, join the NAA. We'd love to have you. We believe that we're a home for all appraisers, and especially those appraisers that currently belong to no organization.
Thank you, John. A few things here real quick. I have a comment. It's not really a question, but it's a comment from my good buddy, Mr. Bobby Crisp down in Texas. You guys know him. He said, I still use the word apparent in my reports. I have to. Sometimes I can't be so specific. I'm just not that good. And I would argue that Bobby's pretty dang good. I love you, Bobby. You're going to have to join us on one of these real soon. Listen, that being said, we've been talking about wins and wins and wins for appraisers today. So I'm really excited about this great news. One final thing, and I guess I didn't mean for it to be a teaser, but I guess it will. Fannie Mae Freddie Mac has announced working on a new form. So maybe that's a win too. I don't know. Maybe it's not. But maybe, Bobby, we could kind of get a seat at the table and convince them to put apparent back on the form. There's some things that we need to do to help clients, help intended users, and help appraisers facilitate better communication of our thoughts and opinions and conclusions. We can make this thing more concise. You know, there used to be a form called the Green Hornet many, many years ago. Boy, we've seen a lot of things evolve over the years, and sometimes we make things more complicated than they should be. Guys, we're out of time. I would like to thank both of you for being here today. Mr. Craig Capilla out of Illinois and John Dingeman from California. Thank you very, very much for being here. If you'd like to let everyone know one more time how to get a hold of you, go right ahead. Craig?
All right. Well, the easiest way to get a hold of me, hopefully it got posted. I tried to put it up there. www.charlesfranklinlaw.com is our website. You can find my email address on there, or you can email me directly at ccapilla@charlesfranklinlaw.com. If you ever have any questions, concerns, if I got something wrong, I love to hear about it. Please do not hesitate at all to reach out, and we're always happy to take the question or direct you where we need to direct you so that you get the help you need.
Thank you so much, Craig, for being here. I truly, truly, truly appreciate it. John?
NAappraisers.org is the website. Go there, check it out. You can actually download a copy of the Williamson versus Metropolis, for example, if you want to read it in detail. We do post those things there, what we've done. Try to find your state organization, et cetera. If you want to reach me directly, president@naappraisers.org. Regarding the new forms, Brian, I would say, you know, for those that know me, I'm persistent and I'm a bulldog, and I'll just keep going and going and going. You and I had an opportunity to meet with Fannie Mae. We knew that they were coming out with or developing some sort of roundtable. We were kind of rebuffed there, told, yes, that's nice. I know you'd like to join, but we're not sure we need anybody. I've stayed on that. I think I got the attention of Freddie Mac. And I think I got the attention of Freddie Mac because their recent letter where they announced the forms, they have now added that they are seeking input from associations, for example. So pretty cool.
Yeah, absolutely. And we're going to be talking about that on an upcoming webinar. I'm hoping to have Fannie Mae on one real soon. So guys, stay tuned for that. And boy, wouldn't it be great if we could get some appraisers at the table with Fannie and Freddie talking about how to design and develop this new form. And guys, I think it might happen. I really think it might happen. So if you're interested in that, reach out to Craig, John, or myself, or reach out to Fannie Mae or Freddie Mac directly and see if you can get a seat at the table as well. It'd be really nice to have a boots on the ground appraiser participate in that process. It would be really, really nice. My name is Bryan Reynolds. You've been watching the Appraisal Report webinar hosted by Appraiser eLearning. Thank you for being here. We hope to see you on an upcoming webinar very, very soon. Until then, have a great day and be safe out there appraising, folks.